Court fixes April 18 to hear Nnamdi Kanu's 1 billion naira suit against Nigerian government and the DSS. Good morning, good afternoon, good evening, wonderful people, also freedom all over the world. Wherever you're joining us from today, you're highly welcome to this wonderful YouTube platform that gives you quality news and quality information on all the activities happening in Biafran territory. So if this is your first time of joining us on Let's Talk TV, you are highly welcome. And do not forget to like, comment, and also turn on your notifications so that you can get notified whenever we drop our spanking news. But one thing we are sure of doing here on Let's Talk TV is to give you the legit and the confirmatory news on all the whole issues happening in the Biafran struggle, and all the issue of Mazi Nnamdi Kanu. And the issue I carry on for you is the court hearing of Onyendo Mazi Nnamdi Kanu. Well, actually, speaking about that, yesterday was the hearing of Onyendo Mazi Nnamdi Kanu, where the court, where Federal High Court has also shown its illegality. Should I use the word of illegality or bias? Biased nature of the Nigerian government. This has actually been their thing. They have continued to prove that they are incompetent to handle the case of Mazi Nnamdi Kanu. No wonder Biafrans want the case of Mazi Nnamdi Kanu to be moved to the United Kingdom, because after all, he was actually abducted from another country. But without wasting much of your time, let us give you the news update on that issue. Yesterday was the court hearing, and it was a boring one actually, because it did not go well in favor of Mazi Nnamdi Kanu. It's just the normal thing we've been hearing and we've been seeing, because as it stands, we know fully well that the Nigerian government does not hold anything against Onyendo Mazi Nnamdi Kanu, and everything that they are doing is attributed in making sure that they find a way to keep Onyendo Mazi Nnamdi Kanu so that they can continue to bend the case for as long as possible. Maybe they want him dead, but the fact and the reality is that come what may, nothing can actually happen to Onyendo Mazi Nnamdi Kanu, because the level Onyendo Mazi Nnamdi Kanu is, both spiritually and otherwise, is not the level that anybody can actually attain or think about at this point in time. What is driving Onyendo Mazi Nnamdi Kanu is beyond the Nigerian government. The news in detail. A Federal High Court sitting in Abuja on Monday fixed April 18 to hear a 1 billion naira compensation suit filed by Nnamdi Kanu, leader of the indigenous people of Biafra IPOB, against the federal government and Department of State Services DSS. Justice James Omotosho adjourned the matter after Kanu's counsel, Aloy Jimako, indicated his interest to respond to a counter-affidavit jointly filed by the DSS and its Director General. Upon resumed hearing, Benga Oladimeji, who appeared for the federal government, informed the court that they were yet to file their response on behalf of first and second defendants, because he was only being notified about the process on Monday morning, though they had been served since March 6. Oladimeji prayed for an adjournment to enable him respond appropriately, but the DSS lawyer Abdul Danlami said they had filed their counter affidavit in opposition to Kanu's plea. Ejimako then sought an adjournment to enable him file a further affidavit in response to fresh issues raised by the DSS in their counter affidavit. Justice Omotosho adjourned the matter until April 18 for adoption of processes. In the originating motion, dated and filed December 4, the applicant sued the federal government of Nigeria FRN, Attorney General of the Federation, AGF, the DSS, and its Director General as first to fourth respondent, respectively. The suit was filed pursuant to Order 2, Rules 1 and Rules 2 of the Fundamental Rights Enforcement Procedure, Rules 2009, among others. In the motion, the detained indigenous people or Biafran leader prayed for 8 reliefs. He sought a declaration that the respondents' act of forcible seizure and photocopying of confidential legal documents pertaining to facilitating the preparation of his defense, which were brought to him at the respondent's detention facility by his lawyers, amounted to denial of his right to be defended by legal practitioners of his own choice. He described the act as illegal, unlawful, unconstitutional, and an infringement of his fundamental right to fair hearing as enshrined and guaranteed under Section 36C by B and C of the 1999 Constitution as amended, and Article 71C of the African Charter on Human and People's Rights. Kanu therefore sought an order of injunction restraining and prohibiting the respondent from their act of forcible seizure and photocopying of confidential legal documents brought to him at the detention facility by his lawyer. Kanu also sought an order compelling the respondent to issue an official letter of apology to him for the infringement of his fundamental right to fair hearing. But in a counter affidavit dated and filed by the DSS on March 12, the security outfit denied the allegation leveled against it. In the application deposed to by Yamuje Benye, a legal department staff, he said 11 paragraphs in Kanu's affidavit were untrue. He therefore averred that Kanu was in safe and secure custody of the DSS and that he was not detained in solitary confinement. According to Benye, the applicant, Kanu, is allowed access to his family members and team of lawyers on his visiting days without any hindrance whatsoever. He also argued that the indigenous people or Biafran leader was permitted to interact and consult with his lawyers on his visiting days without any interference. He equally averred that at no material time did any DSS personnel seize or confiscate documents brought to Kanu by his lawyers or any other person. Benya added that their personnel never denied Kanu's lawyer the professional liberty to perform their lawful duty of discussing, consulting, and interacting with him. According to him, Kanu, along with his counsel, were permitted to consult and interact on visiting days in one of the best interview facilities of the DSS to ensure maximum comfort of the applicant and his visitors. The officials who denied allegation that the personnel usually record their interaction during visits said there is no basis for eavesdropping and recording of their conversation. He said, in line with the Service Standard Operation Procedure (SOP) of the DSS, all visitors to its facilities are subjected to normal routine security checks and items in their possession scanned. According to him, this is to avoid unauthorized materials making their ways into the facility. Benye said the instant suit was an abuse of court process, as Kanu had argued the same issues before Justice Nyako and the matter reserved for judgment. And that is all the whole issue on the hearing of Mazi Nnamdi Kanu, what the Nigerian government are trying to defend. But we know the reality on the issue of Mazi Nnamdi Kanu's court case, because it is something that is no more hidden. Forget about all these counter affidavits and blah blah blah, that the DSS are trying to cover. The reality is that we know that Mazi Nnamdi Kanu is under solitary confinement. No matter what they want to say, the DSS has actually been they've actually been lying on so many issues, concerning Mazi Nnamdi Kanu. They have failed to do the needful. They have failed to, obey the court. For me, honestly speaking, the whole issue of, Mazi Nnamdi Kanu undergoing, still under court trial, for me is a total waste of time, because the judiciary have actually proven that they do not have the final say on the issue of Mazi Nnamdi Kanu. That is the reality, and that is what we are seeing. Because if truly, they have the final say, you gave a ruling in favor of Mazi Nnamdi Kanu, a court of competent jurisdiction, not once, not twice. You gave a ruling in favor of Mazi Nnamdi Kanu. First of all, the Nigerian government never obeyed the court's hearing, yet they did whatever they felt like doing and kept Mazi Nnamdi Kanu still under the DSS custody. And yet, we are still arguing the issue of Mazi Nnamdi Kanu when the court did not even obey. When the DSS rather did not even obey the court hearing in the first place. What are we arguing? What are we still defending? You're defending and you're trying to bring an innocent man, to justice according to your law. How do you argue? How do you tend to bring an innocent man down? You're just bringing up, issues against this man, and yet you cannot pinpoint one thing that Mazi Nnamdi Kanu did that is against the court hearing. What are we even saying? Please. You cannot bring out one particular thing Nnamdi Kanu did, you claim that he did, that is against, international law and the law covering your so-called country. And yet we are still on this case of Mazi Nnamdi Kanu. Do not forget that this same case we are talking about, international community had to even warn Nigeria, in as much as they've all pretended and they are keeping deaf ears on the issue of Mazi Nnamdi Kanu. Yet you don't want the people to speak up. You don't want the people to leave your country. Yet you keep on trampling on these same people that you do not want to leave your country. I just don't understand. Mazi Nnamdi Kanu is an innocent man. He has been tried. He has been proven to be an innocent man. He was given, a judgment in his favor. The Nigerian government needs to do the needful. All this adjourning of cases is just a total waste of time to keep an innocent man under the DSS custody. On that note, I say thank you once again for joining us. Please go to the comment section. We want to hear your own input concerning this matter, because as it be, this matter they vex everybody. As at least every lover of Mazi Nnamdi Kanu and every true Biafrans are not happy over the issue of Mazi Nnamdi Kanu. On that note, please like and also comment as you turn on your notification so that you can get notified whenever we drop our spanking news. Thank you for joining us once again.